So the way it's going to work, and this is a simplified process that I'm laying out to you, is it gets administered through the CWC. Once the city decides to challenge an assessment, the town has the ability to say whether they want to go into the TLAP process or not. Now, we fully assume that CWC is going to be engaging in advance outreach to towns before you get to that point where you're not simply going to have to decide, when the city knocks on your door and you got, a week to decide whether you're going to want to do in TLAP. You'll be educated and know about it before, and you'll have the opportunity to decide whether you want to participate or not. And if you don't, fine, you're on your own. And if you're in, that's good, and the city is obligated to participate in the TLAP process and to abide by its rules as long as you want to do it. And so the city will go forth first and prepare the valuation report, depending again on what the asset is that is being taxed, and fit it into the template. And that's, that's a pretty expensive undertaking, and they're going to have to share all of that data with the town. The CWC will then will work with the town and identify and retain the expert to review and vet the city's report, whether it's an engineer or a land appraiser or both. And you're going to go through and look at the city's report where the city came up with numbers and look at their backup data, and your experts are going to say whether it makes sense or not, whether it's a number you should adjust, whether you should accept, or whether maybe there should be an adjustment. The city miscalculated wrong. It should be a slightly different number. And then we think the primary disagreement, again, will be on lands underwater, but there could be on anything else. And it is assumed that the parties will work together in a confidential manner. There are going to be confidentiality requirements on everything, to try and result in a negotiated number, the proper number of what the template is. And if it is, it goes in, the city's bound to do it, and you're all set. If there's a disagreement on specific items of the template, you can go to litigation on that specific item. Now, this is another good thing for the town. You're not required to throw the whole thing out and start from scratch as if you had never participated in the program, which was one of the things the city originally wanted if you weren't in TLAP. And they could force you to say, well, we're not going to agree on one of the line items. Again, primary one would be land underwater. And you would lose everything else, where we've negotiated the multipliers for all the different things. You wouldn't get the add-on factor, you wouldn't get the factors for the soft costs and everything else. There would be a stipulation of litigation just on that narrow issue, which reduces the uncertainty and reduces the cost to the town. Now, the city is not going to pay the town for its litigation. You are going to be on your own to an extent. You're going to have to front the money for litigation, so obviously this is going to be a natural break on you doing something unless you think the city's really being unfair in the process. And that's what we were protecting against. We wanted to make sure that the city was acting in good faith in the negotiations, and then, of course, the town's acting in good faith, but they always do. If the town goes and wins on that valuation report, on that template litigation, and succeeds with a final value by the court that is 15% or more higher than the city's last offer, so that's different from the valuation report. If the valuation report came in and say at $1,000 an acre for the land underwater, but the city negotiated up to $2,000, and you think it's $4,000 or something, it should be more, and you go to litigation. If you get at least 15% over that last $2,000 offer, not the original report value, then you win. So it's a protection on that. The city will pay 2/3 of the town's attorneys and expert fees with a cap of up to $90,000. I don't know if that's enough. I think it's enough. We tried to get more. They wanted to do dramatically less. But that's where it is. That's the best we could get on it. But I think it's a fair number. And the incentives are built in for the city not to litigate that way. And because we've limited the litigation on the template to such narrow issues, the cost of litigation are not going to be anywhere near what they were for CWC under the tax consulting fund, where we had to take care of the whole ball of wax. How about that? We lose. I'm not sure there is much of a downside, to be honest. I mean, it is far better than any assessing authority has, at least in the state of New York, on any similar kind of project and any kind of a thing. I mean, nobody has these benefits where you are forcing your biggest single taxpayer to engage in this process where they bear the cost of developing a template. They agree to these parameters. They pay your attorney's fees if you a good chunk, 2/3 of your attorney's fees if you substantially prevail. The interesting thing on the dynamics, and we always, have our own tunnel vision on things, and when we think about what the city is doing and, what a behemoth they are and how unfair, and they've got all the great resources. I mean, we were dealing with the city's tax attorneys, who are certainly no cream puffs, right, Carl? and they give us a very good perspective, is because they're usually 90% of the time in our position. They're the taxing authority defending their assessments against the big utility lawyers or the big real estate landowners who have the resources and beat them up. And they didn't like being in the position, they thought it was unfair. And so it balances out that way. I guess the only downside on this is it's not a $3 million or $5 million tax consulting fund where we had unlimited funds to litigate this forever. But that didn't work, and it wouldn't happen again, and it didn't really, solve the problem. So, if there are smarter tax attorneys out there than those of us who worked on this and think that they can negotiate or litigate and end up with a higher number than the template system that we've laid out, go forth and prove us wrong.